Thank you, Mr. Chairman. Thank you, Mr. Secretary, for being here. And I was going to resist the temptation for this North Dakotan to get into the Migratory Bird Treaty Act proposed rule, but I am going to this degree, to simply tell you I applaud the decision. I really don't think you had a lot of choice on this, because it's not just a matter of one solicitor's opinion versus the next solicitor's opinion and the back and forth. That's part of the problem in our regulation. But there's also there are also mixed rulings in court, district courts. And in North Dakota, we didn't have a BP spill, but we did have 3 oil companies that were zealously prosecuted by the U.S. Attorney's Office over 28 birds that flew into a pit someplace, in various pits over the course of months, and died. And clearly that wasn't intentional. Clearly this was lawful commercial activity, and it was more of a representation of the hatred for the industry than it was the love of birds, the way that the U.S. Attorney's Office at the time went after these companies and consequently the workers. Fortunately, there was one willing to stand up to them, and it was thrown out for all the reasons that this new rule, this proposed rule states. And I have great sympathy for what Senator Van Hollen's talking about, but there's got to be a better way than simply punitive zealous prosecution of lawful commercial activity, regardless of the magnitude of it. And hopefully we can find a balance in all of this, find a balance that's not so punitive, but rather cooperative and collaborative. And so with that, with my remaining minutes, I want to spend this time to flesh out a little bit your views on the waterfowl production area easements that you've been active in, and start out by saying, first of all, thank you to Senator Bernhardt, or to Secretary Bernhardt for first of all coming to Hope, North Dakota last year, touring on a very chilly day, some wetlands, and then coming up with the recent director's order just earlier or I guess last month, that really demonstrates once again, that the Trump administration cares about rural America. As you know, the enforcement of these pre-1976 WPAs has been confusing in many cases. It has been a long-standing issue for our landowners, oftentimes resulting in both unnecessary and far too often, again, zealous enforcement measures, excessive confrontation with law enforcement, and more to the point, the federal footprint in these WPAs only grows with time, even though there are very specific purchased acres in these pre-1976 easements. That oftentimes this results in a de facto, really what I call a regulatory taking or a land grab. And according to the January 3rd director's order, throughout 2020, the Fish and Wildlife Service will be sending updated modern maps, thank you very much, to landowners who have these pre-1976 easements. And they will be accompanied by the first ever appeals process, again, thank you very much, so that landowners can make sure that the maps are done properly. The most fundamental protection for a landowner is an accurate map. And clearly the technology in 1976 and previously doesn't match what we have today, and consequently a lot of this confusion. To that end, I want to just ask a few fundamental process-related questions so that the public knows what to expect, because once the letters go out, and I expect they're going to go out soon, landowners will only have a short time to respond to them, to sort of put the stake in the ground. So first of all, Mr. Chairman, what I'd like to do is ask unanimous consent to submit the director's order and a recent op-ed that I wrote and was published this week in North Dakota newspapers.
But without objection.
So could you maybe just help me in the last minute, or help people watching this, by describing the quality of the pre-1976 maps and why this is even important at all, to provide some clarity to our landowners?
So would you ask that last question, sir?
Yeah, could you explain why it's important that we do this at all, and talk about the quality of the pre-1976 maps versus today, and why it's important to update this?
We've made, I hope that you will agree, good progress with your constituents on trying to provide some transparency. A lot of those wetlands protection areas that were signed up pre-1976 did not have complete maps. There was disagreement handed down from generation to generation about just what we'd committed to do. And by, I think we've got 5,000 pre-76 maps we've committed to get out to your constituents in in the coming years, with 1,000 this year. We've also have an appeals process that is going to help them have some peace of mind that they're going to get a fair hearing if they disagree with what the service has said. And I also think we're looking at the way we approach your landowners in terms of trying to represent to them that there may be a disagreement about the wetlands protection area. So those three are, I think, already underway, and we're now looking at tile setback regulations and appeals process for drainage tiles.
To that, I would say amen, 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 and amen to all of them. Thank you for doing that. Yeah, it's a lot of amens, but it's a lot of good news. And I think it gets to the point, though, that all of us have been talking about, that the best way to do conservation is collaboratively, cooperatively, whether it's with sportsmen, landowners, oil companies, whatever the case might be. And so let's, amen.